I'm Pamela Sokach, and this is a testimony for Bill number 160, Code of Ethics. I'm a United States citizen, and I'm a healthcare practitioner, and I reside in South Kona, Captain Cook. As a United States citizen, I am a protected person as defined by international criminal law in the Tadic judgment of 1999 by the International Criminal Tribunal for the former Yugoslavia Appeals Chamber, which stated that civilians who are nationals of the occupying state are also protected persons because their allegiance while residing in the occupied state is, in this case, owed to the Hawaiian Kingdom and not the United States. Allegiance to the Hawaiian Kingdom by resident aliens is stated in Section 3, Chapter 6 of the Hawaiian Kingdom Penal Code. I too have come to learn that the Hawaiian Kingdom continues to exist as an independent and sovereign state that has been under an illegal, and prolonged occupation by the United States since January 17, 1893. I am also aware that the United Nations independent expert, Dr. Alfred Desaias, sent a memorandum to the members of the State of Hawaii Judiciary, which stated international laws, the Hague and Geneva Conventions, require that governance and legal matters within the occupied territory of the Hawaiian Islands must be administered by the application of the laws of the occupied state, in this case the Hawaii Kingdom, not the domestic laws of the occupier, the United States. And according to Amnesty International, war crimes are crimes that violate the laws or customs of war defined by the Hague and Geneva Conventions. Article 43 of the Hague Regulations and Article 64 of the Fourth Geneva Convention obligates the United States to administer Hawaii Kingdom law, not United States law. This deliberate failure by the United States to administer Hawaiian Kingdom law has led to grave breaches under Article 147 of the Fourth Geneva Convention and international humanitarian law, which constitutes war crimes committed against me as a protected person. This body illegally enacts the United States laws in violation of the Hague and Geneva Conventions, and as a victim of war crimes that stem from this unlawful legislation, I demand that this body immediately cease and desist.
My name is Robert Freitas Jr., and I am testifying on behalf of Bill 160. I am a Hawaiian subject. I am retired, and I currently reside in Kona. As a Hawaiian subject, I am a protected person as defined under Article 4 of the 1949 Fourth Geneva Convention. I too have come to learn that the Hawaiian Kingdom continues to exist as an independent and sovereign state that has been under an illegal and prolonged occupation by the United States since January 17, 1893. I am also aware that the United Nations independent expert, Dr. Alfred Desaias, sent a memorandum to members of the State of Hawaii Judiciary, which stated international laws, the Hague and Geneva Conventions, require that governance and legal matters within the occupied territory of the Hawaiian Islands must be administered by the applications of laws of the occupied state, in this case, the Hawaiian Kingdom, not the domestic laws of the occupier, the United States. And according to Amnesty International, war crimes are crimes that violate the laws of or customs of war defined by the Hague and Geneva Conventions. Article 43 of the Hague Regulations and Article 64 of the Fourth Geneva Convention obligates the United States to administer Hawaiian Kingdom law, not United States law. This deliberate failure by the United States to administer Hawaiian Kingdom law has led to grave breaches under Article 147 of the Fourth Geneva Convention and international humanitarian law, which constitutes war crimes committed against me, a protected person. This body illegally enacts that civilians who are nationals of the occupying state are also protected persons because their allegiance while residing in the occupied state is, in this case, owed to the Hawaiian Kingdom and not the United States. Allegiance to the Hawaiian Kingdom by resident aliens is stated in Section 3, Chapter 4, Chapter 6 of the Hawaiian Kingdom Penal Code. In 2015, Hawaii County Council was made aware of the Hawaiian Kingdom via Testimonial Resolution 185-15, and on June 2nd, 2015, you voted unanimously recognizing La Ho'iho'i'ea, Sovereignty Restoration Day, as a holiday. Why didn't the council members ask Corporation Counsel for legal opinion at that time? In 2016, several of us that included Dr. Keanu Sai, Mr. Kale Gumapak, and myself met with council members Karen Eoff and Miley Maderas David, where Dr. Sai provided both council members with the same information that was provided to council member Ruggles.
Please summarize.
Why didn't you, Karen Eoff, or you, Miley Maderas David, ask Corporation Counsel for a legal opinion at the time either? It is also important to note that council member Ruggles did not ask Corporation Counsel Kamehameha for his personal assumption and or opinion. She asked for a legal opinion based on applicable laws. Over the years, in many of our testimonies before the County Council, many of us have been providing a lot of this information to you over and over again. So for any of you to say that you are unaware that Hawaii is illegally occupied or that war crimes are being committed is a blatant lie, and you know it. Do you realize that once you are made aware of the truth and you ignore it, that makes you an accessory to the lies, which in this situation makes all of your accessories to the war crimes that have been and are continuing to be committed? Do you realize that you are about to commit another war crime, but continue to enact United States laws in violation of the Hague and Geneva Convention, and as a victim of war crimes that stem from this unlawful legislation, I demand that this body immediately cease and desist.
Thank you for your testimony. Now we will go to Kohala with your